4:14 p.m., March 10th, 2022. My name is Judge Barrett. We're on the record in 22 CR 371. This is the Tina Peters matter. She appears in custody via WebEx from the Mesa County Detention Facility. We're here today for an appearance on the arrest warrant, hearing on advisement. Her attorney, Mr. Jovanovich, is here in person. Good morning, or afternoon, Mr. Jovanovich.
Good afternoon, Your Honor. Jason Jovanovich, 032703, appearing for Ms. Peters. Thank you.
All right.
I think Mr. Corporon may be on the WebEx, but I don't see him up there, but he's also co-counsel with me locally in Colorado.
All right.
Oh, there he is.
All right, Mr. Corporon, good afternoon to you, sir. For the people, Mr. Rubenstein is here in person, as I mentioned a moment ago, set today for hearing on advisement and that appearance on an arrest warrant. Mr. Jovanovich.
Judge, I'm sorry, Mr. Shapiro is also appearing for the people.
I neglected to mention that twice now. Mr. Shapiro is here for the people as well, appearing via WebEx. Mr. Jovanovich, now what would you like to do today, sir?
Thank you, Your Honor. Two things. One, we'd like to waive any formal advisement at this time. The second thing is we'd like to address bond. Currently, there's a $500,000 cash-only bond. I would like to make the argument as to why that should be reduced to a PR bond or something similar to what the co-defendant received.
All right, go ahead, sir. And then you can come over here to the lectern whenever you're ready to make arguments.
Well, firstly, my client has no criminal background. She's a public figure, a public official, and at worst, she's accused of doing her job that she's constitutionally and statutorily supposed to do. This isn't a case that involves any violence, drugs, or sex offenses. She has companion cases where she's made appearances. She's had me as an attorney for a number of months now, including several other attorneys who I supervise and also who I work with as local counsel. She's involved in an election now. She is generally a good citizen. She's a Gold Star mother. Her father passed away while she was in the jail last night. I want to bring that to the court's attention. I brought it to Mr. Rubenstein's attention as well. But we don't have anybody that's a flight risk here, Judge. She's a public figure. She's a public elected official who has duties and obligations. I was approached by Mr. Rubenstein, and I appreciated on a similar sort of restrictions for my client as for her co-defendant. However, because of my client's constitutional and statutory obligations and her position as clerk of the court, she cannot agree not to have contact with the clerk's office or employees of the clerk's office themselves. She doesn't have any problem since co-defendant agreed not to contact her, agreeing with that. We have no problem with not contacting directly witnesses or anything like that are listed, but we do and would object to any restrictions that prevent her from doing her job as an elected official. I don't think those requirements are connected enough to the main purpose of bond, which Your Honor knows is to ensure the attendance of the defendant here. Here we have no record of failures to appear. She does have a misdemeanor case and a contempt case, which I think touches upon Your Honor's court, but she has in no way ever failed to appear or deal with anything here. Given the circumstances of her losing her father, given the circumstances of her being in an election, and even the federal courts generally decline and the federal prosecutors decline to get involved in cases where an elected official is in the process of running for re-election. So the fact that she's here in this circumstance in and of itself is unusual, but there's nothing about her that's unusual. Our position is that she's done her constitutional duty, that the evidence will show that she had reason to do what she did, but there's no violence, there's no threat to the community here. As I said, she's engaged me since the summer to be dealing with this along with other attorneys, so she is submitting herself to the authority of the court and of all the judges that she's in front of. However, bond is not to be punitive, and we feel that currently $500,000 for a Gold Star mother who's an elected official is just punitive, Your Honor. It has no correlation with her appearing in court. So we'd ask that you give her a PR bond of $10,000, just like her co-defendant. I know that we object to some of the things that Mr. Rubenstein wanted to do, but it's for good reason. And also, I'd remind the court and everybody here that my client is presumed innocent until proven guilty. And so, other than accusations from an indictment, and the old saying goes, Judge, that you could indict a ham sandwich. I don't find that persuasive enough for the court to continue with the bond as it's currently set. I appreciate your time and allowing me to make the argument, Your Honor.
Yeah, thank you, Mr. Jovanovich. Mr. Rubenstein, for the people, what say you?
Thank you, Judge. I'm never moved by the statement in a bond argument that the defendant is presumed innocent. In all bond arguments, the defendant is presumed innocent. The purpose of bond nonetheless exists and exists for purpose. Ms. Peters' situation is different than Ms. Knisley in that since the time of the grand jury indictments, dates of violation, Ms. Peters has continued to spiral, including having the situation which led to her attempting to donkey kick police officers on video. That was an effort of her to not submit to law enforcement authority. That resulted as the direct product of her refusing to submit to the court's authority when the court issued a search warrant to obtain her iPad, and she wouldn't comply with the search warrant. That was the direct result of her, in this court, being investigated for potential attempting to influence a public servant and contempt charges, in which we exercised the considerable discretion not to charge her with the felony attempting and merely as a situation for the court to decide what to do. She's been removed from her election authority after a different court had already found wrongdoing by her. And I really take issue with the statement of Mr. Jovanovich. At worst, she is accused of doing her job. No, that's not actually the situation at all. A grand jury has returned indictments on 7 felony counts and 3 misdemeanor counts, essentially saying that she was not doing her job. She was acting well beyond, and there's official misconduct counts that they found probable cause for her going, purporting to do her job and doing things that were against the law. So for all of those reasons, and given that she is accused in that indictment of conspiring with her co-defendant and conspiring with others in the case, being a complicit with others, to use her elected position to be in the situation which allowed her to commit those illegal acts, I think is entirely appropriate for the court to issue the same bond conditions as the court did with Ms. Knisley. That is no contact with co-defendant Ms. Knisley, no contact with those same victims that I gave the court the sheet of paper on: Jesse Romero, David Underwood, Stephanie Wenholz, Danny Casillas, and Gerald Wood. No contact with any of the employees at the clerk and recorder's office who she also and where she also committed these acts. No contact with those 2 addresses. I will tell the court there is precedent for this. I know when the DA down in the 7th Judicial District was investigated, I believe, under indictment. It's actually Mr. Shapiro's case. He was precluded, even though he was the elected DA, from going back to that office, and the Attorney General's office ultimately ended up sending somebody over to handle those responsibilities. And I think that's happened before. It's entirely appropriate in a situation where the elected official is using their elected official status to put themselves in the position to commit those offenses. Given that Ms. Peters also has a history of leaving the state, disappearing for long periods of time on the private plane of Mr. Lindell, we are also asking that she surrender her passport and not be permitted to travel outside of Colorado.
The type and amount of bond?
Regarding the type and amount, Judge, I'm not sure where the $500,000 came from. As the court knows, it's pretty standard protocol in this jurisdiction to do no bond until first appearance, which was what was originally issued. Somehow, sua sponte, the court, not Your Honor, I think it was Judge Larson, changed it to a $500,000 cash. That was never anything we were consulted about or even told about. I learned about it from my PIO when she started getting questions about it. If Ms. Peters would be willing to agree to those conditions that I just listed, I think those conditions would make the community safe from her, and a PR bond would be entirely appropriate. If she does not seem willing to agree to those, then we would ask for a secured bond.
Thank you. The primary purpose of bond is, as Mr. Jovanovich said, to ensure that the defendant appears at each and every future court date. However, there are other purposes of bond. They are to ensure compliance with conditions of bond, community safety, as well as victim safety. When fixing bond, the court is required to consider a host of factors, which include but are not limited to defendant's ties to the community, the reputation and character of the defendant, the nature of the charges, possible penalties, history of appearing for court, criminal history, and any empirically based scoring instrument that may assist the court in understanding the defendant's risk level should he or she be placed on bond. I've considered the arguments of counsel. I've considered the file in this case. I've considered all other statutory factors for fixing bond, even though I may not have mentioned them here today. I note that there is no empirically based scoring instrument that has been uploaded for my review in this matter. I take Mr. Jovanovich at his word and as an officer of the court that the defendant does not have a criminal history that has convictions, nor has she missed court dates. I note that the allegations in this case are very serious. They are allegations that go to the very heart of her employment and are alleged to have been acts that undermined the democratic process. I also find that Ms. Peters has allegedly engaged in an act of contemptuous conduct before this court, and that she has allegedly engaged in an act of resisting arrest while a search warrant was attempting to be served upon her. All of these allegations suggest someone who may not and will not comply with bond conditions absent an appropriate bond being set. She has 3 open cases or matters at this time as well, this, of course, being the most significant. Mr. Rubenstein alluded to her previously leaving the state of Colorado and being at an unknown location for a period of time as well, which is concerning to the court. Given all of these factors, considering the severity of the allegations and the defendant's lack of criminal history, I do find that a secured bond is appropriate, although not in the amount as currently set. I will order as follows. A bond is set at $25,000 cash or surety. If it is cash, the money must be posted in Ms. Peters' name and her name alone, not by a third party. Conditions of that bond are identical to those of Ms. Knisley. No contact with co-defendant Ms. Knisley. No contact with victims Jesse Romero, David Underwood, Stephanie Wenholtz, Danny Casillas, or Gerald Wood. No contact with any employee of the Clerk and Recorder's Office. No exceptions. No contact with the Clerk and Recorder's Office at 3225 I-70B, Suite A2, Clifton, Colorado, or at 200 South Spruce Street here in Grand Junction, Colorado. Given the nature of these allegations and how they are directly related to her employment at the Clerk and Recorder's Office, I find it appropriate to make it such that she is not to have any interaction with the employees of that office or to be present at the work sites for that office. She is to surrender her passport within 48 hours of being released from custody as well, and she may not leave the state without first getting permission from the court. Those are the conditions of bond. That is the type and amount of bond.
Judge, may I have just a moment to confer with the defense counsel?
Yes.
Thank you, Your Honor.
About the 25th, I'm sorry.
25th. We were thinking of using that May 25th date that was previously was going to be made available to the other litigants.
Judge, and that was the date that we originally came up with for Ms. Knisley before we realized that she had her pre-trial conference the day before. I assume the court is available for a normal docket on the 25th, and that's why you offered it?
The 25th is not my normal docket. I set this off docket. It was not to disrupt my normal docket.
So this will not be with Ms. Knisley, with whom she now has a no contact order, but it was the date that we had previously discussed for Ms. Knisley before we moved it.
Or if Your Honor has another date that you would prefer,
no,
might be accommodating to the court.
I don't find that them crossing paths in the courthouse would constitute a violation of the no contact order. This is a place where those types of interactions, I should say crossing the paths, can occur. I would prefer to do it at the same time just so that I don't take up other time on my docket for other individuals who could use that time. So what I'll do is I'll simply set Ms. Peters for 8:45 in the morning on the 24th of May.
And just to remind Your Honor, we did combine Ms. Knisley's with the pretrial conference. I don't know how long the pretrial conference will take.
It'll take as long as it takes. 8:45 in the morning on May 24th, and then if it spills over past 9, I do jury trial set then, so I'll just call the jury in later. Work for you,
All right.
Mr. Jovanovich?
That's all I have, unless Mr. Corporon has anything that he needs to add. You're good? All right.
Are you good, Mr. Corporon, or are you raising your hand? Okay.
Okay.
Very well. So that'll be in person as well
right.
for Ms. Peters.
Sounds like Mr.
hold on.
Corporon needs to talk.
Mr. Corporon, what is it that you wish to say, sir?
Thank you, Your Honor. This is a change in the bond statute, but since effective last September, jails are required to provide provisions for posting a cash bail online, and that is to be implemented by January 1st of this year, pursuant to 16-4-102 subsection 2B2. I could not find any such provision for doing so with the jail today, and I wondered if I could get any information if that is doable. If not, in light of the death of Ms. Peters' father, I was going to ask the court to come up with an alternative solution for her.
I've issued my order on bond. I do not work for the sheriff. I do not know what their website says. The issue is no longer arguable. Mr. Corporon, you can appeal it if you'd like. The bond is, as I said, it is set with the conditions that I set. She is employed. It is the least restrictive bond I could impose in order to ensure the purposes of bond are met. Is there something else that you wish to address, Mr. Corporon?
No, sir.
Thank you. Now, Mr. Jovanovich.
Yes, sir. Your Honor, because of the death of her father, we would like to move for an exception for purposes of funeral and so forth. Would you like that to be filed in a formal motion, or can we address it now for her to leave? Her father was residing in North Carolina, and she has a 93-year-old mother.
When is the funeral set for?
We don't have, she just found out last night, Your Honor, and so I don't have as much information as I would like.
So then let's get that information, and then you can file papers with me and consult with Mr. Rubenstein. If there's no objection to it, then I will rule on it very quickly.
Okay.
I tend to rule on all matters relatively expediently. If there is an objection to it, then I'll make sure that the DA responds to it in such a time as to afford your client more than enough opportunity to get to wherever she needs to go and make arrangements upon my ruling.
Thank you, Judge. I would have filed something before the hearing, but I just found this out about a half hour myself. So thank you very much for your guidance.
All right. Anything else?
I don't think I have anything else today, Your Honor. Thank you very much for your time.
All right, Ms. Peters, your next court date is May 24th, 2022 at 8:45 in the morning for an arraignment. We'll see you then, ma'am. We're adjourned. It's 4:01 p.m. on March 10th of 2022. My name is Judge Barrett. We're on the record in 22 CR 372. This is the Knisley matter. This is an appearance on an arrest warrant hearing on advisement. Ms. Knisley appears in custody via WebEx from the Mesa County Detention Facility. Her attorneys, Mr. Reich and Ms. Roy, are here in person. Good afternoon to both of you.
Good afternoon, Your Honor.
For the people I have, Mr. Rubenstein in person. Good afternoon, Mr. Rubenstein.
Good afternoon, sir. And Mr. Shapiro from the AG's office, who's specially sworn in under my authority, is appearing as well.
All right. Good afternoon, Mr. Shapiro.
Yeah.
As I mentioned, we're set today for a hearing on advisement and an appearance on an arrest warrant. Mr. Reich, Ms. Roy, what is it that you'd like to do today?
We are in receipt of the indictment. We waive a formal reading or advisement of the indictment. I believe after conferral with the district attorney, we'd ask to set an arraignment out about 60 days so that we can obtain discovery. And then we'd like to address the issue of bond, please.
All right, go ahead, sir.
Judge, may I go first?
Typically, the defense goes first. It's their motion, but
We have an agreement.
okay,
on
go ahead.
Subject to the court's approval.
All right.
First, Judge, with regard to the request to set it out 60 days, we have no objection to that. I did mention to defense counsel that at the time of concluding the grand jury, we had filed a motion to authorize us to release transcripts to them. Once they have filed their oath, the requirements for the oath are detailed out in the motion, and I've notified defense counsel of that. So the request for setting it out for 60 days is to provide them enough opportunity to get that filed and for me to get them discovery, including those transcripts, which not all of them are prepared at this point. With regard to bond, I'll let the court know that well, obviously this case is in front of Your Honor. Ms. Knisley has appeared for all of her court appearances. To my knowledge, she has not left the state. She's been in contact with counsel, who has been in regular contact with me throughout, so I have no reason to believe that she is a flight risk, nor am I aware of any other anything else that would indicate a public safety risk since the time of this, and as the court is no doubt aware, the date of violation of this, it took some time to get through the investigation. So the fact that she's picking up another case isn't because of new contact that causes a public safety concern. The main issues that the people are concerned about is contact with co-defendants, victims, and other clerk and recorder employees. As such, we've agreed that she is willing to abide by these conditions, which is no contact with the co-defendant, Tina Peters, no contact with the victims, Jesse Romero, David Underwood, Stephanie Wenholz, Danny Casillas, and Gerald Wood, no contact with any employees of the clerk and recorder's office, with the exception of Alex Walker, who dates her granddaughter, and no contact with the clerk and recorder's offices at 3225 I-70B, Suite A2 in Clifton, and 200 South Spruce Street in Grand Junction. Subject to those conditions, if she's willing to abide by those, we have no other public safety concerns and are okay with the court imposing a PR bond.
Mr. Reich, is that acceptable to your client?
That is, Your Honor.
All right. Thank you, Ms. Roy. Anything you want to add to that, ma'am?
No, Your Honor, I think if the court is going to go along with it, if the court would like to hear more about her ties with the community, we're obviously ready and willing to present that to Your Honor, but if the court is going to go along with the agreement of the stipulation of the parties, we would ask for this.
No, I don't need to hear anything further on that. But what I will need is a list of those conditions more concisely written out for me so we can attach them to the minute order and they can be reflected on the bond paperwork, since you went quickly and I was not able to capture all of it.
Sure, Judge, if I can just have a moment to show this to defense counsel.
Sure, go ahead. And while you're doing that, Ms. Knisley, did you hear the conditions of bond that the people are requesting, ma'am? Yes or no?
Yes, Your Honor.
And you understand all of those conditions, yes or no?
Yes, Your Honor.
And you'll follow all of those conditions of bond, correct?
Yes, Your Honor.
All right, thank you.
May I approach, Your Honor?
Yes. All right, I'll note that I've considered all of the purposes of bond as laid out by statute. I won't repeat them all here, but I've nevertheless considered them. Considered the request of the prosecution, which is joined in by the defendant. I find that the bond request is appropriate. I'll set the bond in the amount of $10,000 personal recognizance. Conditions of that bond are that the defendant is to have no contact with the co-defendant, Tina Peters, no contact with the individuals Jesse Romero, David Underwood, Stephanie Wenholz, Danny Casillas, and Gerald Wood. No contact with any employees of the clerk and recorder's office, with the exception of one Alex Walker. No contact with the clerk and recorder's office located at 3225 I-70B as in Bravo, Suite A2, Clifton, Colorado, or 200 South Spruce Street, Grand Junction, Colorado. Those are the conditions of bond, the amount of bond previously fixed by the court. Now, another court date, 60 days out or so. For an arraignment, is that how you characterize it? A continued arraignment, Mr. Reich, is that right?
Yes, please.
All right. May 25th off docket at 8 in the morning, in person.
That works for the people. Mr. Shapiro, does that work for you?
May 25th at 8 works, Your Honor.
And I didn't hear Mr. Shapiro, but did he shake his head or give a thumbs up, something along those lines? I don't believe you can unmute yourself, Mr. Shapiro. I saw the thumbs up.
Thank you.
All right, May 25th. I guess he can unmute himself. May 25th at 8 in the morning, in person, Ms. Knisley. That'll be your next court appearance for a continued arraignment. Anything else in this case, Mr. Reich?
No, Your Honor. Thank you.
Mr. Rubenstein?
We have nothing else on this case. We just did want to bring up to the court, we still have a motions hearing scheduled next week, I believe, on the other case. And I think the only remaining motion, which was the scope of the trial motion, was not one that required evidence. I didn't know if Your Honor was intending to vacate that or not, and we don't need an answer now. I just want to put that on your radar while we're all here.
The people had said that they intended to put on some evidence as it related to the motion to dismiss. I didn't know that my order on the same resolved that particular request or didn't, but it seems to me that you believe my order did.
Yes, sir. Yeah, the evidence I was going to put on, it appears that the court did not need that evidence for the theory or grounds upon which you ruled on that motion. It was the motion to dismiss. The only remaining motion is the scope of trial motion, which I do not believe requires any evidence from my side, and I think defense has indicated the same from their side.
Mr. Reich, what's your opinion on what I would consider to be a request to vacate the motions hearing next week?
We would join in that request. I think the issue's been argued, been briefed. I think the court's going to rule.
Right.
I don't think that there's any evidence I can provide that's going to probably change the court's mind in one way or the other. So,
about the motion to dismiss that I've already ruled on. That's what you're referring to?
Yes, the scope. Yes, correct.
Okay. Well, the scope, I haven't made up my mind. I haven't issued any orders on that yet. So I'll do that in the normal course, and then I'll go ahead and vacate the hearing for next week then, since all parties seem to agree that there's no reason for it to remain on the court's docket. And that means her next court date in that case is when?
It's actually the last day of May is the trial, and then I think we have
You should have a pretrial conference.
Actually, pretrial conference is May 24th.
Right.
Maybe we could do the May 25th.
Same day.
Do it on the 24th.
Yes.
Oh.
So, Ms. Knisley, then what we'll do, actually, how about we just do May 24th at 8:30 then? We've already got that time set. So we'll just do May 24th, 8:30 in the morning, Ms. Knisley, for both of your cases in person. This case will be an arraignment. The other case will be a pretrial readiness conference.
And Judge, can I just confirm with Mr. Shapiro that works on his calendar?
Mr. Shapiro, all right, thumbs up. Okay.
Nothing further from the people, Your Honor.
Anything else, Mr. Reich, Ms. Roy?
All right, Your Honor, thank you.
Thank you all very much. Have a good rest of your day.